for joining me on this Daylight Sunday Talk Show.
Thank you very much, Ruben.
Okay, first, let's start with the certificate saga and the voyage of discovery that certain parties to the 2023 presidential election have embarked upon in the United States. And you've been quoted as saying, well, in the U.S. jurisdiction, President Tinubu can plead the right to privacy and non-disclosure, but can that, court tomorrow take a decision on the basis of public policy? And if a decision is taken on the basis of public policy or public interest, would that have any relevance in a foreign jurisdiction? Since the discovery that Judge Gilbert was talking about was about discovery for use in a foreign jurisdiction.
Well, my position is that the proceedings in the United States court tomorrow will be centered on the plea by President Tinubu to have his private right protected, as well as the insistence or the plea by Alhaji Atiku Abubakar to have the records disclosed in the public interest. So the judge will have to marry the two and, come out with a decision. If the court holds that the right of President Tinubu should take precedence, I'm sure that will not be the end of the battle. Alhaji Atiku Abubakar is likely to file an appeal, and vice versa. If the court also rules in favor of Alhaji Atiku Abubakar, President Tinubu may also file an appeal. So either way, it's likely to be a long drawn-out battle. But unlike here, where because of congestion of cases, matters of this nature may be subjected to some adjournment. In the United States of America, and as you have seen in the case, speedy trial, speedy hearing is encouraged. The last proceedings were conducted via telephone, So you don't have to assemble all the lawyers and interested parties to come and sit and wait for the judge. You just simply had a telephone conversation and the judge, made his order. So those are lessons for Nigerians, lawyers and judges or the legal profession, and indeed the entire country. Those are lessons to learn from the case. Okay. So that's the way I look at it. And if, of course, at the end of the day, if Alhaji Atiku Abubakar succeeds, again, go on.
No, what I wanted you to also look at is the relevance. Can the discovery for use in a foreign court be relevant in a foreign jurisdiction like Nigeria's? Considering the level that the presidential election case has reached, will it be admissible before the Supreme Court of Nigeria? The Supreme Court not being a court of evidence. So of what purpose would this voyage of discovery
my understanding, be? Now, if Alhaji Atiku Abubakar succeeds in the United States, he will have to register the judgment in Nigeria. And once the judgment is registered, I guess there will be an application to the Supreme Court. And the task before the applicant will be to convince, for his lawyers to convince the Supreme Court, to admit the record, while the respondent's lawyer, that's President Tinubu's lawyer, will also want to convince the court that it's too late in the day to admit the record. So it's going to be an interesting battle, legal battle, as it were.
Okay, but given...
I cannot personally, I mean, I cannot preempt the court. That would be unprofessional. I mean, the Supreme Court, by saying categorically and affirmatively that the document will be admitted or not admitted. No, I cannot say that.
Anyway, but one major issue in this process is Tinubu's counsel pleading severe and irreparable damage. What does that really mean in real terms? You know, just record of academic qualification? Well,
again, as I discharged Charles a few days ago, I think that question ought to be directed to the lawyer and his client. I'm not in a position, because for me, once you're a public figure, the question of privacy simply doesn't arise. In the case of Otto Nwankwo and the state, the Court of Appeal, I think in 1983, made the point that if you are a public officer and you feel too irascible or uncomfortable with public issues, you better cover your 2 eyes, 2 ears with cotton wool, you know, so that you won't be disturbed by what people say around, you know, I mean, about you. So I do not understand what the lawyer meant by that statement. Because once the university has confirmed that President Tinubu attended the institution and that he's our graduate, right? I understand that Elijah Atiku Abubakar, you know, to be saying that, okay, yes, I now want to have the details. All Elijah Atiku Abubakar is saying is that, yes, since you have confirmed that President Tinubu attended the university, can we have the details? That's all.
Okay, the other subject I wanted to discuss with you is a protest over the hike in students' fees. And we've seen quite a number of university students protesting. Students of the University of Lagos, University of Jos, Obafemi Awolowo University. And in most of these cases, what you have found is that maybe for the faculties in the humanities, the school fees may have been increased from maybe 28,100 naira to 120,000 naira. And for sciences and medical students and faculty of pharmacy, maybe to about 190,000 naira. And parents and you know, students are saying, no, this must not be increased because the right to free education is constitutional. Is the right to free education constitutional? Should the federal government of Nigeria bear the burden of the payment of fees for students at the tertiary level?
Well, in the first place, these protests remind me of the Ali Must Go protests of 1978. I was privileged as an undergraduate, my first year in the university, to have taken part in that historic protest. And I think the argument then and now is that the Nigerian state has no right to commercialize education. Education is so basic. And that is why it is enshrined in Section 18 of the Constitution that the Nigerian government will provide free education, affordable education